The broadcast is now starting. All attendees are in listen-only mode.
Hey, good afternoon, Realtors. This is Byron King, your General Counsel in Columbia at the South Carolina Association of Realtors. It's April 2016. This is our webinar on professional standards, fair housing update, and some forms issues. So we'll talk about some news to start out with. Yesterday, the South Carolina House had a second reading of Senate Bill 1013. This is the Realtor License Law update that we've been working on for many, many years. If you're receiving the Realtor Voice email on Fridays, you'll have information on that. If you participate in the call to action on it, thank you. And our lobbyist, Lindsay Jackson and Sarah Patterson, put that Realtor Voice together and email it out to all 18,000 members on Fridays. If you're not getting that, please contact SCR and let us know. Mike Crest is here in the studio with me. Sharon DeLea wanted us to mention the annual conference is in Charleston this year at the Francis Marion Hotel, September 13th through the 15th. So Sharon and Mike will have the registration up soon. As soon as that goes out, try to register as soon as possible. There's only 100 rooms. We anticipate the annual conference September 13th through 15th in Charleston selling out. And then moving into our program, really wanted to update you something that has come up fairly recently with fair housing. And regarding fair housing, that's your Article 10 in your Realtor Code of Ethics. You can read here on the screen. Duties to public, Article 10, realtors shall not deny equal professional services to any persons for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors in their real estate employment practices shall not discriminate against any person or persons on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, and gender identity. There's also state laws administered by the South Carolina Human Affairs Commission and federal fair housing laws administered by the U.S. Department of Housing and Urban Development. Those protected classes are a little bit shallower than the realtors. The realtors added sexual orientation and gender identity a few years ago. But the news that's coming out of fair housing is this. In 2015, the U.S. Supreme Court decided a case saying that fair housing based on a disparate impact claim could move forward as a fair housing complaint. Disparate impact is kind of a fancy legal term, but basically what it means is something that on its face, or there might not be evidence of actual discrimination. We all know that actual discrimination is bad, but this would be something that statistically show impact of protected class, even though on the face of whatever rule that was applied did not look like it was a violation of fair housing. So that happened in 2015, and then recently in 2016, U.S. HUD General Counsel sent a memo. And since it's a general counsel writing about the law, it's a fairly important memo. And with that memo, the big news is criminal records. So based on this Supreme Court case from a year ago, the HUD General Counsel's memo basically says that in leases, in leasing decisions, and evictions, and evaluating tenants, having a complete blanket rule that nobody with a criminal record can rent here or can live here is going to be a fair housing violation based on disparate impact. And here's kind of the history behind what the memo said. You've all seen the news reports and all that claims that the U.S. criminal justice system may be slanted a little bit, statistically at least, against people of color. Some of the protected classes, the race, color, national origin protected classes. So because the justice system and the statistics, the HUD will view any kind of blanket, just uniform rule, anybody with a criminal record can't rent here, can't live here in our properties, is going to be a fair housing violation. Now, communicate with NAR, yes, you cannot make a blanket rule, but you can apply, you can apply some common sense to it. So you really need to have instead of a one-step process that you could have before this memo, now I have a two-step process where you basically say, okay, we did a background check on this potential tenant. came up with a conviction for a crime. They've got a criminal record. So at that point, you'd probably want to call the hotline or talk to your attorney. You evaluate the crime. You look at, does this crime relate to safety? How long ago was this crime? What kind of rehabilitative steps have gone on? What kind of letters of reference or offsetting information would factor into that? So clearly somebody that's a danger to community, somebody that's done some sort of violent crime, drug dealing, drug manufacturing, all that's clearly a danger, and the feds recognize that. You could evaluate that and say, hey, that because of that criminal record, of that conviction of that specific type of crime, that relates to safety in our rental properties, and we're going to deny the ability for you to move in, or even to have language in our lease that if you're convicted while you're living here, we can begin eviction procedures for a breach of the lease. So main thing, do not have a blanket rule. And blanket rules are going to get you in trouble, a lot of times, especially with fair housing. So no blanket rule. You cannot just say you got a criminal record, you can't live here. You've got to have a two-step process where if they have a criminal record, you look at the criminal record and determine, is it related to safety issues for this tenancy? Is it related to living here? Is it some sort of drug distribution, drug manufacture, some sort of violent crime? And then you can make a decision. But always safe to talk to your attorney or the legal hotline at 800-233-6381. And we were at the Affordable Housing Forum yesterday in Columbia. Nick Romitis and myself, Byron King, at a legal track, and this issue came up. And all the professions, because it's fairly new, the ink's kind of still wet on the memo, so to speak. So there's not a whole lot of concrete information on it, so stay tuned. But I did want to make you aware if you do any property management, this could be an issue. So you want to make sure, if I've got a blanket rule about criminal records, can't live here, that you need to make that a two-step process. You got a criminal record, then we're going to evaluate that criminal record. Does it relate to safety or drug distribution or drug manufacture or violent crimes? And then always talk to your attorney is a safe answer. So Affordable Housing Forum was a great forum if you get a chance to go in 2017. Great thing. And also for the realtors, the way we raise money for Habitat builds is through sales at the realtor license plate. So make sure you go to SCDMV and pick up a license plate. That's how we fund housing builds around the state. So kind of what we'll do is we'll go, that's kind of the big news. That's really what I wanted to do this in April for. April's Fair Housing Month, so really wanted to get that out to you because it's big news. We're working with NAR. If you're going to NAR mid-year meetings in May, NAR is scheduled a couple discussion forums on this issue. But it was a very hot topic at the Palmetto Affordable Housing Forum yesterday. Also at that forum, they announced the Palmetto Heroes loan program, down payment assistant, low interest rate is out basically for first responders, soldiers, teachers, nurses. Basically the Palmetto Heroes program you've seen in the past. Ed Knight, who works for South Carolina Housing, so they've got about $12 million. So they do not expect that funding to last more than about 4 to 6 weeks. So if you've got buyers that may fit that program, go to SC Housing or Google Palmetto Heroes and check that program out. That's kind of our affordable housing, fair housing month information here. And we've talked about Article 10. And in the code, you can see Article 10, you've got the base article, and then you've got standard of practice. So you got 10.1 says when involved in the sale lease of a residence, realtors shall not volunteer information regarding the race, religious, or ethnic composition of any neighborhood, nor shall they engage in any activity which may result in panic selling. However, realtors may provide other demographic information. And standard practice, these are basically clarifications of the base Article 10. Standard practice 10.2, when not involved in the sale or lease of a residence, realtors may provide demographic information related to a property transaction or professional assignment to a party if such demographic information is A, deemed by the realtor to be needed to assist with or complete in a manner consistent with Article 10 a real estate transaction or professional assignment, and is obtained or derived from a recognized, reliable, independent, and impartial source. The source of such information, any additions, deletions, modifications, interpretations, or other changes shall be disclosed in reasonable detail. And standard practice 10.3, realtors shall not print, display, or circulate any statement or advertising with respect to selling or renting a property that indicates any preference or limitations or discrimination based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. This is the thing where they talk about, you may want to put the fair housing symbol, the little house with an equal sign on there. If you're using models, people modeling in your photographs, try to be diverse with age, disability, race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Standard practice in 10.4, as used in Article 10, real estate employment practices relate to employees and independent contractors providing real estate related services and the administrative and clerical staff directly supporting those individuals. So the idea is to try to be inclusive and diverse, include people and serve people. Basically try to treat everybody the same. Will keep you out of trouble a lot of times. Unfortunately, this disparate impact is kind of an aberration to that rule. You actually can't treat everybody the same. You have to look. If there's a criminal, if you're checking for criminal records, check everyone and evaluate the same, but you cannot have a blanket rule, just criminal record, you can't live here. You have to do kind of a two-step process. Criminal record, how does that record relate to safety and the rental, drug dealing, drug manufacture, violent crimes, and then you even look at, hey, how long ago was this? What's the person done since then? Are there any offsetting factors? So that's kind of the background on that. So kind of switching gears to forms. Let's go back here for a second. Get into this. I wanted to show you the website. Mike Crest, Sharon DeLid did a great job updating the website. This is the screaltors.org website. A lot of great information for you on here. You can kind of see how the big news kind of scrolls across the top. The next page, member benefits I want to talk to you about. This is all your member benefits of being a member of SCR. Forms and contracts we're getting ready to talk about. Legal hotline, you basically have two staff attorneys, Byron King and Austin Smallwood, and then your CEO, Nick Romitis, is also an attorney. We try to help you out with any kind of questions about professional standards or ethics or arbitration or mediation or standard forms or ethics or license law. And we talk about the license law update going through kind of the big picture items in license law update. We're talking about adding a definition for material adverse fact, increasing education, addressing some teams. Right now, the word team does not even appear in license law, so the new license law teams have evolved since the last time license law had a major overhaul in 2005, adding some language to teams, how you advertise, how you operate an agency. And adding, the big change will be adding transactional brokerage. This is, you may have heard it by various names, facilitator, transactional brokerage. This will really help our commercial folks, but it'll even help residential folks in those scenarios where you get a buyer that says, hey, I want to look at houses, but I do not want to sign a buyer agency agreement. You'll be able to help those folks. It'll help us with some procuring cause arbitration issues. And it'll define limited function referral office, which is not in license law right now, so that should help your local boards come to do collection time to talk to licensees. So governmental affairs, we talked about that. We got the second reading on Senate Bill 1013. If you want to read the bill, you just go to scstatehouse.gov, search for S1013. S stands for Senate, Senate 1013. Got second reading in the House yesterday. Thanks to all those legislators that have been working hard on this issue for a number of years. It's our webinar series. I'll show you where those are in a minute. We have webinars. This is one of them. I'll give you some information, market reports, compile data across the state, and enable you to talk to sellers and get them to reasonably price their listings. Tech helpline, we'll talk about that in a minute. You can call anytime, pretty much anytime, and get technology help with your cell phones, your laptops, your iPads. You've got a subscription to Inman News, which is kind of the Wall Street Journal of real estate. Everybody always want to try to get you to invest in RPAC to help us with our governmental affairs issues. Realtor Education Foundation, then we got a leadership program. If you're interested in getting involved in committees, the NAR committee sign up is on right now. We ask you to sign up for NAR committees and ask you to sign up for SCR committees come October. Leadership SCR is a series of retreats where you kind of learn about the association and develop yourself as a leader. So if that's of interest to you, join. If you know somebody that would be a good leader for the association, please send their name to us. And then your member discount below, AT&T, Brooks Brothers, UPS, and then Inman. But this is kind of your Inman. You basically just set up your account as a member. You get a free account. That's about a $100 retail value for you there, and gives you the news on Inman on the real estate industry. Tech helpline, here's the number here. You want to write this down, get it in your speed dial, 877-573-5607. Can help you with any kind of tech issues, emails, printers, gadgets, and we get good feedback on people that use it and love it. And then you got the hotline. There's me and Austin. It's got our phone numbers. Legal hotline. Got some information on interpleader. We'll talk about earnest money right now. Kind of the safe answer on earnest money is called the hotline. We'll talk about why in a moment, but you're always safe to get a signed disbursement agreement or a court order on that. And then Zip Forms Plus, you've got access to all the forms in Zip Forms. You've got a mobile product. You can have people sign using their tablets or their phones. You've got unlimited digital Zip Forms digital ink for e-signatures that'll replace some UPS and FedEx shipping costs for you and save you a lot of money. And we talked about the webinars. They're all on our SC Realtors YouTube channel here. And we've got as many videos as you care to watch. You can kind of see, some of you tuned in today think it's going to be an in-depth forms. It's really not, because we're kind of time limited. But if you want something updated and more in-depth, we've got several. You can see on the front page right here where I'm moving the cursor. We got an hour-plus long webinar on the forms from 3 months ago. And even if you scroll down here, we've got another one from a year ago, another hour going through the form almost line by line. I think there's about 4 or 5 forms webinars on here, but different things. You can see David Kent, your president, talking about license law here if you're interested in that Senate Bill 1013. And right below David, you can kind of see some of the market reports here. And so we encourage you to get on the Realtor YouTube channel and watch it at your leisure. A lot of good information there. So Zip Forms, I had it logged in. I was going to try and show you my account, but it kind of logged me out. But anyway, you just set up your account. This is really good because you don't have to print and get an ink pen and fill everything out. You fill out a cover sheet, it auto-populates. You can set up templates. As a broker, you can manage your agents through here. You have an electronic record of all your transactions. It makes you look professional. You'd be able to email contracts to your potential clients and customers. And you can kind of see below Zip Forms Plus is what you get with your membership. Digital Ink is your unlimited e-signature product that we've added as another member benefit. And I've got management system there for the brokers and even some MLS and mobile benefits to you there. All right, so I wanted to talk about forms a little bit. So we're kind of going to talk about several forms. We're going to talk about some of the ones we get a lot of hotline calls about. This is form 312, a rejection of offer form that Candace Pratt down in Somerville Real Estate Commissioner helped us develop. And we're going to talk about the residential form, the repair procedure addendum, repair request addendum, rather I should say, sale contingency addendum, and also due diligence. So anyway, this is a form we're getting a lot of calls on the hotline. The market's improving and we're getting more calls about multiple offers. So this is a form you can use in 2 situations. So the first one, it's a rejection of offer. So you can use it to reject offers and send a form back to the buyer and buyer agents. Hey, the seller rejects your offer. This is often useful for a buyer agent that maybe wants some documentation that their offer got presented. License law says you can present all offers to the seller. So this is a way you can document it. Interestingly, there's in the Senate Bill 1013 that got second reading of the House yesterday, there's a provision in there that LLR will develop a rejection of offer form. Basically a form seller, actually the listing agent will sign and say seller rejects the offer and give you a little bit of documentation. We get some hotline calls occasionally. Buyer agents are unsure that their offer didn't get lost or not submitted, so this is a way to document that that got submitted. And so the second way you can use this is to reject all offers and actually solicit new offers. So this is useful for a multiple offer scenario. So remember the MLS is an invitation, a solicitation of offers. So MLS is not, it's not Walmart where there's a price on something. So the house, is listed in MLS at, $500,000. That does not mean a buyer can come up and offer $500,000. You have to sell it to them. The MLS is an invitation for buyers to submit offers, and then the sellers can either reject those offers, counteroffer those offers, or reject those offers, or do nothing. So so that's a common hotline call, and you're going to see more often, full price offers, offers for more than full price, especially multiple offers. So a lot of times new buyer agents will call the hotline and say, hey, Byron, my buyer offered, full list price. Don't have to sell it to me. No, they can reject or counter offer or do nothing. But you're going to see that more often as inventories maybe tighten up or there's more buyers in the market than sellers. So this form, you basically, buyers rejected, you just check the box, all buyers, or these named buyers, and you could write them down. If it's just, you're rejecting Byron King's offer, it's not multiple offer, you check Byron King, or it's going to be a multiple offer scenario. You talk to the seller, hey, bird in the hand, two in the bush, we got a good problem, we got multiple offers. You can accept one or counter one, that's kind of the bird in the hand. The two in the bush proverb comes in where we say, hey, you may get more money if we reject all these offers and give them a highest and best deadline. But there's the chance these buyers go buy something else. But more than likely than not, they're probably going to come back and offer you more money. So a seller makes that decision and say, hey, I think I want to go for, reject the bird in the hand and go for two in the bush. And so you would reject all buyers, and you would write down the address of the subject property. And then 4, you can even say, seller invites buyer to submit a new offer containing new terms. Seller appreciates potential buyer's interest in purchasing the property. Seller does not accept and rejects buyer's offer or counteroffer. Seller is not making an offer or counteroffer to the buyer. Instead, seller invites buyer to submit a new offer to seller. Seller suggests the buyer's offer to be the highest and best terms of offer include new terms that equal or exceed these suggestions. So highest and best means you put in your best terms. So that's price, it could be a quick close, it could be, hey, I'm an all-cash buyer, it could be, hey, I'm using the due diligence addendum and I'm putting a very high due diligence termination fee to make that attractive to your seller. But in these blanks, the seller may want, say for instance, the seller's got some kids that are finishing up, high school, and they want to stay in the house through graduation. They might say, hey, in your offer, put a close date after, June 15th or something like that in here. But are any other terms that the seller might want to say, hey, it's a good idea if you add these into your contract when you submit an offer to me if you want to get accepted. And so the idea is you're setting up a highest and best deadline. But because people are people, sellers are people, and they can do whatever they want to, there's a little bit of disclaimers in here. Number 5, other buyers, competing potential buyers may make offers at any time. Just saying, hey, people are people. They may try to do stuff that's out of the ordinary. We would like to have a deadline. The sellers may distribute offer information. It's part of the code of ethics, talking about offers are not confidential information for the regular residential property. Commercial, maybe they've got enough sophistication. They want to hire a lawyer to create a confidentiality agreement and then sue to enforce that agreement. For a regular residential house, the cheapest, quickest, safest way to get that house, get your dream house, dream property, is to use the terms and use it, your strongest, highest price and your best terms. And then so the seller sets a deadline for submitting these highest and best offers. That's number 6, deadline for submitting a new offer. The seller invites any potential buyers to deliver their written highest and best offers, check at buyer's convenience or to location, which could be, hey, we want you to bring it to the listing brokerage office at 3780 Fernandina Road, Columbia, South Carolina, which is the SCR office. At or before time, you put noon on today or for Friday. You probably want to give them at least a day or two to get their get everything together. So you probably want to give them a little bit of time, but you would set a deadline. And the idea is that everybody has a fair shot at the property. Seller picks the highest and best terms. And the reason NAR came up with this program, it's in the Code of Ethics and Arbitration Manual. As a suggestion, we talked about the bird in the hand and two in the bush proverb. And the idea is that, you guys, I'm a lawyer, so, lawyers, real estate agents, used car salesmen, we're all kind of at the bottom of, the public's trust survey. So the idea is that, in a multiple offer scenario, so there's 3 buyers, one's going to get the house and 2 are not. So 2 are going to be upset, and the idea is, hey, let's make them upset at their capability to, offer a bigger purchase price, not at be mad at the real estate agents that, they may argue, oh, I would have got that house if the real estate agent hadn't played games and been kind of shady. So the idea is to try to give everybody a fair shot at the property. And then it says seller intends to review offers at the stated deadline because potential buyers may rescind their offers or counteroffers prior to acceptance. And buyers are not required to submit a new offer. The seller reserves the right to make an offer or to accept, reject, or counteroffer any acceptable offer or counteroffer from any potential buyer at any time. This is kind of the realtors basically disclosing, hey, people are people. You know, sellers might do something that I can't control as a realtor, so it's kind of putting everybody on notice. But the idea is that most likely you will have a deadline to bring your highest and best offer, and may the best buyer prevail. And then number 7 talks about multiple offers at time of signing. The seller anticipates or does not anticipate or makes no representation, check a box, as to the possibility of competing buyers delivering their highest and best offers by the deadline. Seller desires buyer to have a level playing field to fairly compete at their highest and best offering terms, and so seller warns buyers not to use escalator clauses, but encourages presenting only the buyer's highest and best offering terms. And people are people. You can't control every person what they're going to do, but it's saying, hey, me, seller, warns buyers, please do not use escalator clauses. And kind of escalator clauses, in slang term, it basically means, and you've all probably seen it, you know, Byron King will pay $1,000 more than the next highest offer, up to, you know, $505,000, for example, on that listing we were talking about. So really what I'm trying to do is get the property for less than my highest and best, because my highest and best is obviously that ceiling I put in there, 505. So I'm trying to trick the system and get the property for less than 505 from using escalator clauses. Escalator clauses cause a couple problems. A, the whole goal of this form and this procedure from NAR is for the public to feel like they got treated fairly and had a fair shot at the property, and real estate agents did not play any games or strategies or do anything shady. And escalator clauses, you know, the people that don't get the house might view, oh, well, I didn't use an escalator clause, but Byron did and he got the house. That was kind of shady, so I'm upset at the real estate agents about that. So it kind of defeats the whole purpose of trying to make everything fair and everybody has the same information. Number 2, it's not the seller cannot accept that offer and create a contract because there's a material term price that's not set in the contract. So price is not set without looking at somebody else's contract, the next highest. So it creates some contract problems. So you got the fairness, the contract problem, and then if everybody uses it anyway, they all ratchet up to their highest and best anyway, and a lot of math has to be done. So just avoid that. Use your highest and best terms. And this is the seller warning the buyers. So a buyer agent that tries to be crafty and use this, you know, potentially could find themselves at the end of an Article 1 complaint that they weren't looking after their seller's or their buyer's best, their client's best interest, because the seller warned, do not use escalator clauses. So there's a chance the seller doesn't even look at that offer or throws it in the trash can. And so if the buyer agent was the one that suggested that to the buyer, that buyer that didn't get the property runs into the seller at the grocery store a few months later and finds this out, might turn around and try to sue the buyer agent brokerage, might try to file ethics complaints and license complaints. So the idea is level playing field, same information, and you know, some suggestions. Maybe if people are concerned, maybe it's sealed bids. Everybody seals an envelope, delivers at the deadline. The seller, you know, rips open the envelopes all at the same time and evaluates them. So there's MLS rules that buyer agents can request to be at the presentation of offers. The seller can obviously agree or disagree to that. And the negotiations between the listing agent and the seller are obviously going to be behind closed doors. So they need to sign it, date it, time it as the seller, and then, you know, the buyers get it. They can initial down below if they'd like. It says they've read the page. So kind of what I'll do, we'll kind of try to hold questions at the end. We're kind of on a tight schedule today, but you can always email questions to Byron at screaltors.org or Austin at screaltors.org or Mike at screaltors.org or legal hotline at screaltors.org or info at screaltors.org, or give us a call at 800-233-6381. So that covers the, and we're getting more of these multiple offers, so it's a good problem to have. So congratulations on getting the market, getting the multiple offers, and getting those deals done. This is the contract. It's kind of lengthy. Well, you know, a lot of those webinars that we showed you before on this page cover the contract. So we'll come back and talk about it a little bit, but I kind of want to keep moving through some of these other forms that we've been getting lots of calls about. This is the due diligence addendum. If using the base contract, this is the residential contract, the 8-pager. There's Section 8 is repair procedure. This is the one that's basically in pretty much the same form was in the earlier version of this prior to the 2012 update. It basically says, hey, the parties agree that the buyer is going to inspect by a calendar date and then have 2 business days to get the repair request over to the seller. And then in B, the seller's got so many business days to get their estimates and make a decision. And then if the seller agrees to make all the required repairs are the 9 basic repairs, the operative condition for the HVAC, the electrical, plumbing, water supply, septic, sewer, roof rear leaks, environmental concerns, and structure. Outside of that, that's the only repairs that are required under here. So anything cosmetic or doesn't fit in those 9 categories, for instance, a worn out roof that doesn't leak, that might be better handled if you use due diligence. So due diligence covers a lot of issues. That this is basically just for a buyer that wants a basic house, basically operating, basically structurally sound kind of deal. So if the seller agrees to make all the required repairs, which are these basically just these 9 base repairs to the contract, then you're in contract going to closing. If the seller were to say, I'm going to make 8 of the 9 that you've requested, or if you've requested 2 of them and they'll make 1 of them, or you've requested 1 of the 9 and the seller says no. If the seller says no to 1 of the required repairs, then the buyer has 2 business days to say, hey, it's my dream house, I'm going to buy it anyway, or try to renegotiate for maybe, hey, if I pay a higher price, would you make the repair, or hey, I'm going to terminate this contract and try to get my earnest money back. But we'll come back to this, but I wanted to show this. We've been getting a lot of questions about what due diligence does. Due diligence basically, imagine Section 8, all the stuff about the repair procedure. You could basically erase everything about the 9 classes of required repairs and the calendar date and the deadline for the seller getting his estimates and the deadline for the buyer. Those 3 deadlines, you just imagine this is all erased, and the contract says the latest changes control, so the due diligence addendum would overwrite this. So what the hotline, a lot of times we'll try to use both, and so if you use both, the due diligence will control, but it creates confusion, so just don't use both. Use one or the other. But if you did make a mistake of trying to use both, the due diligence would be the later change would control. So this is due diligence. Due diligence, instead of 3 deadlines, you just have 1 deadline. That's the upside of that is you have 1 deadline. The downside of that is you have 1 deadline. So you have to use some professionalism. Whereas the repair procedure kind of holds your hand. It says you get your inspections done by a calendar date. The seller then has some time to make a decision. And buyer might have some time to make a decision if the seller didn't make all 9. So it kind of holds everybody's hands through the process. And there have been some suggestions to update this due diligence where it does hold your hand. So the Forms Committee may be working on that in the near future. But currently, the way it's written is you put a date in here. Like 10 to 15 business days are kind of common, but as contractors get busier, repairs take longer to get inspections, repairs take longer to get estimates. Depending on your market, you might want to put a bigger number in here. And business days are defined as basically Monday through Friday, 10 a.m. to 10 a.m., not counting Saturdays, Sundays, or legal holidays. Now you have 1 deadline, but under that 1 deadline, it's a very critical deadline that you do not want to miss, and it kind of makes the buyer agent have to kind of hold their own hand. The buyer agent has to go, okay, I've got a due diligence period of, we use 20 business days as an example. The hotline call we had this morning. Said, hey, the market's really hot. It takes longer than 10, 15 days. I said, hey, no problem. Just use a bigger number in this blank. Put 20 in here. So say you got 20 business days in here. What you want to do as a buyer agent is go ahead and get your inspections done. So maybe get your inspections done by, say, day 6, and then you get the repair addendum over to the seller on day 7, and maybe say, hey, seller, we're going to give you 6 days or what have you. So we get to you on 7. This repair request addendum will expire in 6 business days. So that kind of holds the seller's hands. Say, hey, you need to get back to us in 6 days, otherwise we might terminate. So If the seller agrees to make any repairs are negotiable. So any of those non-basic are negotiable. Any cosmetics, you want a new roof, you want new carpeting, new painting, structural, HVAC, plumbing, pool, whatever the buyer needs done to the house, you add all that into one repair addendum. You don't piecemeal it, put it all in one. Because when you send the repair addendum over, that sunsets your due diligence as far as asking for additional repairs. And so after that repair addendum expires, if the seller hasn't agreed to it, then so we had buyer inspected through day 6, you gave 6 days to the seller, so you're at day 12, and that gives you 8 more days to make a decision. Do you want to try to negotiate with the seller? Hey, would you make some more of these repairs if we change the price? What if we struck some of these repairs? What would you be willing to do? Or, hey, I'm just terminating and give my earnest. I'm going to try to get my earnest money back. And so the buyer has some control, but never, ever, ever, ever let due diligence deadline pass without having a new contract or terminating. Because this contract says if you let that deadline pass, you're in an as-is contract. And so as-is is defined as you proceed through the contract. Now, there's still some things in the contract that can still apply to repairs. There's, if you're financing contingency, a lot of times the lender's appraiser may find some things that need repairs. The lender say, hey, you got to fix this or we're not giving you the loan. Then that repair may come up again. If there was some sort of fire or casualty to the house, there's some language in there where the seller can repair or give some money to the buyers or that people can terminate. And then the CO100, the wood infestation report, is still in the contract. So, something comes up with moisture, wood destroying organisms, moisture at a certain percentage, Clemson Extension has said, is indicative of wood destroying organisms. So there could be some repairs coming up to the CO100, the financing clause, the appraisal, or the fire, flood, casualty contingency, and normal wear and tear. The seller's got to fix anything that goes wrong, south of normal wear and tear. So the idea with due diligence is it's very simple. You can negotiate anything. You can walk for any reason or no reason. And that was kind of the resistance when we changed this in 2012. Some of the members said, hey, this is going to hurt our business because it makes it easy for buyers to walk. So we've gotten some feedback over the years, statistics from large brokerages, and found the fallout rate on due diligence and repair procedure is about the same. So, and I think that kind of falls under the category that buyers want to buy, they're going to buy. Buyers that want to walk, they're going to walk. What due diligence is good for, a lot of buyers think they can get it anyway. It solves the unauthorized practice of law issue from agents that were writing in contract contingent on buyer satisfaction with home inspection, which was basically free due diligence that ran the day of closing. And so it made it a little bit fair. It enables the seller to shorten the period. Instead of running to closing, you can make it a number of business days after the original effective date. And it can put some money in the seller's pocket. In the second section, during the due diligence period, buyer may unilaterally terminate this contract by delivering the seller both notice of termination and a termination fee of blank dollars, US dollars good fine. So if the buyer walks, hopefully the seller has negotiated some money. So the seller says, hey, my house was not active in the MLS for 20 business days, and then you walk. That's, I'm glad I got you out of the way in 20 days instead of waiting to closing, but I would like some money. And so this enables the seller to pre-negotiate it. If you walk, you're going to pay me $500, you're going to pay me $1,000, you're going to pay me $2,000, whatever the parties agree to. And then this third section basically reinforces, hey, if the buyer lets that due diligence deadline go by without doing anything, the contract will figure out what happens. The contract says the parties are going to closing as is, which means you basically buy the house with the terms of the contract moving through without the repair addendum, without the repair procedure, without the repair addendum for due diligence. But there could be some repairs that the seller has to think about later through the financing contingency. The lender may require certain repairs via, their FHA, VA appraisers may say, hey, we need a new roof or something like that. It may come up again. Or if there's a fire, flood, casualty, or something happens in the house more than normal wear and tear, or the appliances drop out of operative condition that are conveying, or the C100, the wood infestation report that might pop up again later in the contract because it happens later in the transaction. Some repairs may come up from that. So that's kind of the idea of the due diligence addendum. And this is the repair addendum. You notice it got a lot longer. We've updated the repair addendum. You can see the date down here, January 2016. In February, Greenville and Spartanburg boards adopted the SCR contract, and that made the whole upstate all use one contract instead of 3 contracts, so it makes it easier on everybody up there. But it meant that there were some new eyeballs on the forms. Some attorneys and realtors up there in Greenville and Spartanburg made some good suggestions. We implemented about 12 of their 25 grammar suggestions. They're really good proofreaders. They even caught an extra period that had been in the contract for 4 years that nobody had noticed, and a couple other grammar updates. But one of the things that came up was they said, hey, we want more space. Our repair addendum has more space. So to add space, we went to 2 pages and added 50 lines. So you can see here, this is the repair addendum. And so it says, by request, the seller. This could be used with repair procedure or due diligence. So section 1 says, repairs by request seller to cause, complete in good faith and timely manner the following actions to the property in a good and workmanlike manner while complying with all applicable repair laws, rules, and using qualified repair workers. Any repairs not covered by this contract become the responsibility of the buyer when closing. Repair documents are not attached. You could attach the home inspection, for example, or the appraisal, something like that. Fill all those in. And then the repair agreement is the seller agrees to make timely, good faith repair efforts, complete repairs at seller's expense, and provide reasonable time for buyer inspectors to conduct inspections of repairs and notice to seller of repairs inspection results. The seller can cure any repair issues not later than blank business days prior to the closing date. That's your repair deadlines. The idea is the seller's got to get to work on these repairs. They've got to leave time for the buyer to come in there and see if the repairs got made. They got to leave time if they come in there and say, hey, this repair wasn't made properly. It gives the seller some time to cure that issue, all within a sunset period prior to the closing date. And then it says if seller successfully completes his repair agreement, the buyer waives any due diligence termination rights if parties have agreed to due diligence addendum and shall comply with contract terms. So seller makes the repairs, the buyer is waiving any termination rights, and everybody's moving to closing. If seller fails to complete the repairs in this repair agreement, then the buyer can, hey, it's my dream house, and we'll buy it anyway, such a good deal, and buy it anyway. 2, negotiate and reach agreement with the seller for different terms. Hey, would you make different repairs? Would you compensate me for the repairs that weren't made right? Would you reduce the price? Would you be willing to escrow with a law firm for the repairs? Or terminate the agreement and try to get their earnest money back. And then number 3 says modification of contract upon parties agreeing to this repair addendum to the contract. The buyer waives any due diligence right to terminate the contract if the parties agree to a due diligence addendum. This repair agreement modifies the contract. This repair agreement replaces any agreed upon due diligence. So this is why you only submit one of these under due diligence, because this repair addendum is saying, hey, these are the repairs I want. We're not piecemealing you, seller. You get it all at one time. It sunsets the due diligence termination rights once you submit this and the parties have agreed to it. Now, number 2 modifies it and says, yeah, this sunsets your termination unless the buyer doesn't make the repairs that they've agreed to, and then you can terminate. So kind of handles that. And then the expiration of offer. This causes a lot of confusion on the hotline. People think they can unilaterally extend the due diligence deadline with this. You cannot, because it's one side. The parties have already agreed to a due diligence deadline. So the expiration offer can always be short of the due diligence deadline, but should never be longer than the due diligence deadline. This is the example we used. 20 days due diligence. You get your inspections done on day 6. You give the seller to day 13. And so you make this expire on day 13. That gives you, 7 business days to negotiate or decide to walk. And so the big change in the contract that you'll notice as we update the forms, you can see here the word witness was removed. During our bus tour last year, everybody loved the Zip Forms digital ink. They said, hey, add our witness and electronic signature. So to keep people from having that confusion, we just took the word witness off. So buyers still sign if you're at the kitchen table, at your office, and you want to use a witness, you still have a line for the witness. This also gives you space for those rare occasions where you might have 3 or 4 buyers, and sellers. So that's the repair addendum. And this is Form 504. This is the one we get a lot of hotline calls about. This is the one where, Byron King's got to sell his house to buy this new house. It's a contingency. Just basically say, hey, this contingency, I've got to sell my house, either checkbox blank business days prior to closing or checkbox at closing. And then these next blanks cause a lot of confusion. These blanks basically say, hey, when Byron gets a contract on his house, he's got blank business days to tell the sellers. And when he closes on his house, he's got blank business days to notify him. So basically, how long does this contingency run? Does it run all the way to closing, or does it sunset prior to closing? And then how many days do I have to notify the other side when the house goes under contract or closes? And then I write in my property address that I'm trying to sell, and then I describe it a little bit. It's my primary residence, second home, vacation home, rental, land, commercial, other. Do I need to close in order to get financing? Yes, I can't afford 2 houses, so I'm going to put yes. Is it listed? No, it's not listed right now. If it was listed, that would give the seller, maybe a warm fuzzy that things are going on track. Is it for sale by owner? Yes. Then you might say, hey, Byron's trying to sell it on his own. I'm a little bit leery about how much time I want to give him. I might want to look at, if it's multiple offers, maybe I'll look at a different offer. Or the most favorable, the seller, hey, I've already got my house under contract. Contract's actually attached, so I'm planning on getting that thing closed. The seller would be a little bit more comfortable maybe. And then number 2 is the knockout clause, slang term we hear a lot on the hotline. If during that sales period, Byron King's first in line to buy the house, but the seller gets a cash buyer, wants to close in 10 days, the seller might want to try to knock me out of first position. So you basically let me know, and then I've got a certain time frame in here where I've got to either, hey, I got my house under contract, so I stay in first position. Or I got to move this sales contingency, but I can afford 2 houses. I got $1 million in the bank. I stay in first position. Or I say, hey, I haven't sold my house. It's not under contract. I can't afford 2 houses. I'll either move to back up or I'll terminate and try to get my earnest money back. And you can see this form's a 2013, so it still has the old witness line. We'll update that. We tried to stay on 1 page. Some people said, hey, Byron, go to 2 pages. Make this a little bit easier to read. I think it's hard to read, and it probably is. But what I wanted to point out was this get your earnest money back. I want to make everybody kind of aware the Forms Committee met on April 6th. Peggy Gainey was the chair. Bob Nuttall was the commercial task force leader working on updating the forms. And they talked about some issues that have come up. Primarily the Greenville-Spartanburg were doing earnest money the old way, where you had to get something in writing signed by the parties or get a court order. And so they were obviously a little bit concerned about SCRs. We've got several provisions in the contract to get earnest money dispersed based on, it used to be the #1 hotline call. There would be these disagreements over $500 or $1,000, and the parties wouldn't mediate, the parties wouldn't sign a release, the parties wouldn't sign a disbursement. Sometimes the magistrate wouldn't take jurisdiction. If it was more than $7,500, the magistrate couldn't take jurisdiction. And so a lot of money got stuck in trust accounts. 2009, there was a broker in the Piedmont that was actually shot, nearly murdered by a buyer that was upset about $1,000. At any rate, our Forms Committee in 2011 met with Nexon Pruitt Law Firm, developed a contract that had some contractual disbursement of earnest money based on how we read license law, and our law firm read license law. And so the triggers to disperse earnest money in the contract are obviously due diligence, buyer terminates and tries to get the earnest money back. The financing contingency, buyer tries to get a loan, doesn't get it. There's provision to terminate, trying to get your earnest money back. The appraisal section, house appraises low, the seller doesn't drop the price, the buyer can try to terminate, try to get the earnest money back. Repairs under due diligence or repair procedure, seal 100. Seller agrees or has to make repairs and then fails. There's provision there, but the buyer could terminate, try to get the earnest money back. There's a fire, flood, or other casualty. There's provisions in there about how that's handled with repairs or insurance money or compensation, or provisions for termination, trying to get the earnest money back. And then this form, the sale contingency, where we talked about a cash buyer comes in behind me, knocks me out of position, I can terminate and try to get earnest money back. Here's the issue. LLR staff continues, as recently as yesterday, to make some noises that they interpret license law differently than SCR, and SCR's law firm Nexon Pruitt interprets it. In November 15, the Real Estate Commission discussed this issue. SCR was over there and talked to them, And the Real Estate Commission's been good about giving opinions on other issues like coming soon REO signs and kiosks and malls. But the Real Estate Commission did not opine that this practice of contractual disbursement of earnest money was illegal. Even though we told them, hey, this is under a contract, we've been doing it for 4 years. But because the staff, the LLR staff, making noises recently as yesterday about this issue, here's right now the Forms Committee talked about this issue, sent some recommendations, Executive Committee. But here's kind of the hotline answer right now. It's call the hotline when you have an earnest money dispute. If you have a whiff of a dispute, you're never going to be second guessed by LLR to get a release or a disbursement agreement signed or get a court order. And so that's what we recommend for right now. So that's that. And then we're going to go into some more stuff here. We talked about this is the NAR legal page. It's realtor.org/law and ethics. Down here you can even see about fair housing criminal history. If you want to read more about what we're talking about the disparate impact and criminal records on rentals. So that's a good resource for you. That's the National Association's legal page. This is our code of ethics. So there's basically 17 codes of ethics. 17 is the arbitration, the commission dispute one. Number 1 is kind of, the preamble is the golden rule. Treat other people as you'd like to be treated. Number 1 is be honest, look after your clients. These are they're kind of grouped in a certain way. Number 2 is realtors are not going to make misrepresentations or exaggerations or conceal issues. 3 is you're going to cooperate with other brokers. Cooperation does not include compensation. Compensation is triggered by a compensation agreement or by everyone being a participant in that particular MLS. Article 4 is your conflict of interest. So you got to disclose if you've got an interest in a property or somebody close to you has an interest in the property, you got to disclose that. Some issues with that. Call the hotline if you have any questions about stuff like this. Number 5, realtors shall not undertake provide professional services where they have an interest in conflict of interest. Number 6, another conflict of interest, you got to have informed consent before you make money off of your client. Number 7, in a transaction, realtors shall not accept compensation from more than one party without disclosure to all parties and informed consent. Again, kind of a conflict of interest article. Number 8 is the one we talked about, earnest money. Call the hotline if you've got an earnest money dispute. LLR staff continues to make noises that they disagree with our contractual disbursement of earnest money, so we're working on that issue. But the earnest money is also Article 8, where you have to protect other people's property. Number 9, get it in writing. This is one the lawyers like. This is why you got to do standard forms, get everything in writing so people can't argue about what the agreement was. We talked about Article 10, fair housing, criminal records, disparate impact. 11 is kind of saying, hey, you got to be competent. So to be competent, you got to take classes, get educated, or associate with a realtor that does have experience in education. 12 is one we get a lot of ethics complaints about. That's your Article 12 is your advertising. So that's all things advertising. There's some minor change. The only change in 2016 the Code of Ethics was adding some things about electronic advertising. You got to put your company name. It's a good reminder about the team issue. Always disclose your brokerage company name. Article 13, the lawyers really love this one. This is the one that says realtors are not going to practice law without a license, and they're going to tell their clients and customers to get legal advice when those people need legal advice. 14 is kind of how we get you into an ethics hearing. It says if you're a member, you've agreed when you raised your hand and took the oath to become a realtor that you'd comply with the Code of Ethics. So this basically says, hey, if you're put in an arbitration, commission dispute, or an ethics complaint, you have to go into the hearing and participate in mediation, so forth and so on. 15, don't talk bad about other people. Kind of goes back to the golden rule, which your mama told you if you can't say something nice about somebody, keep your mouth shut. So that's Article 15, and that's one we get a lot of complaints about. Number 16 is probably our next highest complaint. This is the one where people accuse somebody of taking their client. So if somebody's working with somebody, be very careful. Talk to the broker, talk to the other agent if that comes up, call the hotline, because that's a common one. That's also tied in with the arbitration commission disputes a lot of times. And 17 is the commission disputes. That's the money fighting over commission. So we'll talk about some things here. So we have kind of 2 tracks for the hearings. I know this is a jumbled page, but kind of give you the idea. Ethics. So ethics are the articles 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. And then commission disputes, that's Article 17, where you're arguing procuring cause. You were the cause that introduced the property. You were the unbroken chain of events all the way to closing. And so kind of with ethics and commission disputes, in the last couple of years, SCR has taken, with cooperative professional standards, we operate professional standards for most of the local boards except the large boards that have the staff and the meeting space and the volunteers to be able to handle impartial panels at hearings. So the advantage of us at SCR handling professional standards, we got lawyers. Lindsay Davidson does a lot of the administrative work. We do this all the time. We have about a hearing a month. We send out about 10 complaint packages a month. We go to the trainings. We've been doing it a long time. And our hearing panels are all realtors that have no conflict of interest. They're not from the same town. They're not from the same franchise. They're not from the same company. They'll probably never see these realtors again. And so people know when they drive to Columbia for hearing things a little bit more serious, and there's a little bit less concern about some sort of, somebody's friends with somebody, somebody's related to somebody. I've got to do deals with them in the future kind of thing. It's all impartial panel with no really ties to anybody. So there's some advantages. Disadvantage, you got to drive to Columbia to the SCR office, but those advantages are there. So a couple of changes we made this year in the argument, a couple new programs called Ombudsman and Citations. So Ombudsman is ethics mediation. We've always mediated we've always mediated arbitration and commission disputes. But the new thing is we're going to try and mediate ethics complaints as well. We'll talk to the parties. So you'll have a mediator that will call you up. It's already gone through grievance, so you'll have a copy of the complaint. The mediator will call you up. We even recommend you call on the front end. If you've got a commission dispute or an ethics issue, you call the other agent, you call the other broker, you have your broker call their broker, try to work it out that way. But if you do file a complaint or a complaint's filed against you, it will go to grievance committee. They actually operate through telephone as well. They look at big picture stuff. If everything in the complaint is true, would it go to a hearing? And then if it does, then you'll get a call from an ethics mediator, try to mediate a solution between you and the complainant, maybe an apology, maybe you agree to pay him some money, maybe you agree to take some classes, maybe you might write a letter of apology. So that's that. And then also we'll try mediation. That's phone mediation for the ombudsman for ethics. For commission disputes, maybe you meet in person. Mediation is settlement. So there's a mediator that's been trained. If you're interested in becoming a mediator, NAR will have a class in Chicago this year. And so the mediators will meet and try to work out a settlement. The mediator is not the person making the decision. So the two sides work together to come to a solution. The mediator is kind of a peacekeeper. They're trained at keeping the people talking and coming to a solution. They'll write down the solution and sign it without having to hire lawyers, drive to Columbia. Mediation also in a commission dispute will split the money, so you would get something rather than nothing. If you go to a hearing and you lose, you're paying the $500 admin fee, plus you're not getting the commission. So mediation would enable you to save on attorney's fees, save on driving to Columbia, save on preparing for the hearing, and get something without the risk of getting zero and also paying $500 admin fees. So mediation works, try to use it. We try to push that as much as we can. The other thing is citations for kind of some of the minor infractions, typically advertising infractions. NAR has come up with this idea, and you can see here kind of a traffic ticket. You guys are all familiar with how traffic tickets work. You basically, somebody says you did something wrong, the traffic cop gives you a ticket. So this would come, basically it would go to grievance, they would send it to a hearing, maybe try to, ombudsman, try to mediate that ethics, and then it goes to a citation panel. Citation panel looks and says, hey, does this offense fit one of our citations? Typically for advertising, little, kind of honest mistakes. And so you would get a citation in the mail saying, hey, here's what happened. Here, if you decide to pay this, minor fine, this minor education, everything goes away, no permanent record. And just like a traffic ticket, say, heck no, I want my day in court, you could request a hearing. Obviously, you could accept it and move on with your life, but you could also go to court and, present your case, and maybe be found, not in violation. You might be found in violation and receive a higher fine, a higher amount of education. The idea of any kind of ethics discipline is to get you back up to speed, so it's usually going to be heavy on education. So ombudsman and citation are two new things that we've added this year. And if you calling the agent, you calling, about the ethics issue or the money dispute, your broker talking to their broker doesn't resolve it. Ethics, the ombudsman that calls you up and tries to work it out. Mediation over the phone doesn't work out. Arbitration dispute, and you've got a in-person mediation, that doesn't work out. Then you go to hearing. So you drive up to Columbia. You can bring your lawyer or not bring your lawyer. That'd be up to you. And so you would be facing a hearing panel that looks something similar like this photograph, where you'd have a group of realtors up in front of you. You probably never met them before. Probably don't know them. You're certainly not friends with any of them. Certainly not related to any of them. Not in the same company or franchise. And it's going to be kind of a diverse panel to try to reflect the different members' experience. These are all be experienced folks that have been professional standards training every year. And then board counsel will be there as well. But you'd have your full day in court due process. You get to face your accuser, you get to present your evidence, you get to cross-examine witnesses, you get to cross-examine your accuser, you get to make opening and closing statements, you have the right to appeal if you felt like your due process was violated. But this would be kind of an all-day thing. You'd have to drive to Columbia, so I strongly encourage you to try to mediate some sort of, self-settle would be, on the phone call, talk to the other person, brokers talk to each other. If that fails, then maybe trying to mediate it over the phone on an ethics with an ombudsman or an in-person arbitration, commission dispute, mediation, try to settle it. If you go to hearing, there's going to be a winner and a loser, and some ugly things are going to be said between each other in the heat of battle, and it might damage, especially if it's two brokers from the same area, it might damage relationships between those brokers and going forward. So mediation, ombudsman, those are all good ways to avoid the hearing. And the hearing panel is going to make a decision. So if it's ethics, they're going to find you in violation or not in violation. If it's arbitration, they're going to give somebody the commission and somebody not the commission, and it's loser pays the admin fee of $500. So trying to work it out is the bottom line on that. And like I said, we try to be heavy on education. So if you're found in violation, if you take the citation, there's going to be some education. Try to get, because the whole procedure is to get you up to speed. This is all confidential, in-house stuff. But hopefully you would try to, hey, you messed up, go take some education, don't do it again is the idea. And we very seldom, if ever, see repeat offenders. And then we talk about money. That would be the commission dispute kind of angle of it. And then we're kind of back where we started, back on the member benefits page. And then here you got me and Austin and our phone numbers. And down here you can see the office policy manual. We'll be updating the office policy manual if license law, which we expect to pass here soon with implementation date in January, mainly to add transactional brokerage. That's going to have to go in LLR forms for their agency brochure. It'll have to go in all our forms for contracts and agency. So we'll be updating that. We've got a small broker's policy manual dated 2013. You can use this, especially if you're a one-person shop and you say, hey, Byron, I don't need this 150-pager for myself. To comply with license law, you can just use this one-pager 2013. But plan for us to update that. And we'll be incorporating some of our do not call information. We've been getting some hotline calls. Be careful about do not call. Before you call somebody to solicit a listing, you've got to check the federal do not call law. Registry, you've got to check your own brokerage do not call registry. And then you got to be reasonable. You can't call people at 11 o'clock at night and be ugly to them on the phone. So we've been getting some calls about do not call issues, so be careful with that. And then we got a few questions. We got another meeting here coming up shortly. But Mike, do you have any hot questions we got?
Yeah.
But if we don't get to your questions, feel free to email me, Byron at screaltors.org, or legal hotline at screaltors.org, or info at screaltors.org. We ran out of time to get to the main form, but like I said, if you go to the SC Realtors TV, then you can look at a bunch of more forms training than you would ever want to look at.
Okay, we got one person who said, lender told me that one of her high-producing realtors she works with often, who is finding herself in many multiple offer situations, is using the verbal buyer agrees to pay up to $1,000 about the highest offer received, not to exceed blank. The lender said this is allowable for the realtor because there is a specific maximum price.
Yeah, something that specific, probably need to call the hotline. I just want to point out in the forms under Section 6 is the base contract transaction cost. You can actually have the seller agree to pay the buyer's transaction cost of a dollar amount or percentage, but something that specific, please get in touch with the hotline. And then again, if you have any questions, 800-233-6381, email Byron at screaltors.org, register for the Charleston conference, answer the call to actions on license law. If you want to read license law, it's Senate Bill 1013. You can Google it. Transactional brokerage, education, material adverse fact, teams, limited function referral office. And the big news, the disparate income criminal records, if you're doing rentals, make sure you call the hotline about that. You got earnest money disputes, please call the hotline. Like I said, the LR staff, as recently as yesterday at their meeting, are still making noises. They don't agree that there's contractual disbursement of earnest money for due diligence, financing, appraisal, repairs, fire, or sale contingency. Obviously, we disagree with them, but Forms Committee took this issue up and made some recommendations to Executive Committee. But in the interim, please call the hotline if you have something like that come up. And you're always safe to get something signed, SCR 518 release, SCR 517 disbursement, or a court order via magistrate, interpleader, or seller files a lawsuit in common pleas. Thanks for attending.